Hello and welcome to our 2024 Capstone project. For this presentation, we'll go over the legal analysis of students for fair admissions versus the president and fellows of Harvard College. My name is Whalen and I will be later joined by my colleagues Kolten McMacken and Logan Bojanski. So we'll be talking about affirmative action quite a bit here. So just a little definition from Will Kenton. Affirmative action refers to the policy aimed at increasing workspace and educational opportunities for people who are underrepresented in various areas of society. So obviously there's going to be two sides to this court case. The defendant is going to be Harvard College and fellows, which University of North Carolina is one of them. But we're not really going to talk about the University of North Carolina. We're going to kind of mainly focus on Harvard. Um, and then the plaintiff would be Students for Fair Admissions, or SFFA, which was led by Edward Blum back in 2014. So this is a brief overview from or before the 2021-2023 trial. This would kind of cover 2014 to 2019. In 2014, SFFA sued Harvard College, claiming its admission policies discriminated against Asian American applicants, violating the Civil Rights Act of 1964, and also the 14th Amendment, which the 14th Amendment in there is the Equal Protection Clause. So the SFFA argued that Harvard's use of race in admissions unfairly limited Asian American admissions. Harvard defended its policy, stating it promotes diversity and complies with legal precedents. Then in 2019, the federal court ruled in Harvard's favor, finding no evidence of intentional discrimination and stating that Harvard's use of race was lawful and aimed at achieving diversity. This case is pivotal for the future of affirmative action in U.S. college admissions. However, you'll later learn in 2023 that kind of stuff changed. So the key issues, does Harvard's admission policy violate Title VI of the Civil Rights Act of 1964? And is the use of race as a factor in college admissions? And is its implications for affirmative action policies harmful to other applicants that don't really fit into the affirmative action? So the significance, it has it's very impactful to the future of affirmative action in higher education, and it raises questions about diversity, equality, and merit to college admissions. Over the next 5 to 10 slides, we'll talk about the case and the legal summary of this here. All right. So the issue statement: does Harvard College's race consensus admission policy violate Title VI of the Civil Rights Act of 1964 by discriminating against Asian American applicants in favor of other racial groups, thereby consulting unlawful racial discrimination in federally funded programs? So some important facts to lay down here. We got 4 of them. The SFFA, a nonprofit organization, sued Harvard University, alleging that its admission policies discriminated against Asian American applicants. They also sued them for consideration of race in its admission process, which led to unlawful racial balancing and quotas. Harvard defended its policies by asserting that its holistic review process, which includes race as one factor among many, is essential for creating a diverse educational environment. The rule of law. So in 2019, like I said previously, they actually ruled with Harvard. But then in June 2023, they sided with the plaintiff. The case was decided on June 29th. And the courts ruled that Harvard University's race consensus admission program violates Title VI of the Civil Rights Act, which overturned 45 years of legal precedent. And not a lot of people are not happy about it, and there's still a lot of fighting about it today. I guess it only happened a year ago, but I wouldn't be surprised to see a Democratic president or somebody like that actually overturn this ruling in the future. Or I guess the president doesn't really have, you know what I mean, though. The House and them, they'll try and pass a bill to kind of overturn this because it is a big decision, and um, people like Harvard and other Ivy League schools are really pushing for this still, even though it got overturned. So, some exceptions and defenses. Institutions may still consider race in admissions if they can demonstrate no race neutral alternatives would achieve the same level of diversity in the university. And then defenses, Harvard argued that its holistic admissions process, which includes race as one factor among many, is essential for creating a diverse educational uh, environment that benefits all students. And so, some arguments for each sides. The plaintiff, Harvard's admission policies discriminate against Asian American applicants by using race as a predominant factor. The university's policies amount to racial balancing in quotas, which are prohibited. Um, there are race neutral alternatives that Harvard could have used to achieve diversity. So then the defendant, the admissions process is holistic, and they have from the 2019 trial, they had some, I guess, data that they showed to say that very there's still a lot of whites and Asians getting admitted into Harvard, um, kind of pleading their case that they're not being too one-sided to a race in this in their admissions, I guess. And then the goal is to create a diverse educational environment that provides significant educational benefits. And then the third is eliminating the consideration of race would lead to a significant reduction in diversity, harming the educational experience for all students.
So some background information is the affirmative action in the U.S. has a long history for over 40 years. It was first introduced in the 1960s to address systematic discrimination and inequality faced by marginalized groups, particularly African Americans, in areas such as education, employment, and housing. Um, Previous landmark cases were Fisher, a white applicant, challenged the University of Texas at Austin affirmative action policy, arguing that she was denied admissions based on her race. That case was upheld and remanded to be fought in the lower courts. The evolution of policies and public opinion on affirmative action has been a complex and dynamic process, reflecting broader social, political, and legal changes in society. Um, Litigants, Students for Fair Admissions organization aiming to eliminate racial considerations in college admissions. This is led by Edward Blum. Harvard College is the oldest institute of the higher education in the United States. They are also advocates of diverse and inclusive educational environments. Some elements to prove, or the SFA must prove discriminatory intent or effect in Harvard admissions process. Harvard must demonstrate lawful application of affirmative action policies and necessity of consideration of race to achieve diversity. Some legal background of affirmative action is that Title IX ensures that no person in the United States um, on the grounds of race, color, or national origin is excluded from participation in denied denied the benefits of or subjected to discrimination under any program or any activity receiving federal financial assistance. Um, the Civil Rights Act is the landmark piece of the legislation in the United States that aimed to end segregation and discrimination based on race, color, religion, sex, and or national color. Some key legal precedents of affirmative action were Regents of the University of California versus Sprack in 1978, or Gruder versus Bollinger in 2003, or Fisher versus University of Texas, like we talked about in 2013 and 2016. The publicity overview. The affirmative action policies impact how colleges and universities select their students. These policies can lead to more diverse population, which can enhance the educational experience for students. Affirmative action policies will often attract widespread national and international attention because of their impact of social justice and equality. The attention these policies receive underscores their importance in shaping a more equitable society, but also highlighting the complexity and controversies they entail. Some media focuses. Media often highlight racial tensions and policy impacts. Media involves selecting certain aspects of perceived reality and making them more salient into the community. Legal focuses on statutory and interpretation and constitutional principles. Legal focuses on structured facts, evidence, and legal arguments. Some public interest, the old way institutions were doing their admissions process was discriminatory towards Asian Americans as they had lower rates of acceptance despite.
Hello, my name is Logan Bojanski, and for this project, I was assigned the public intersection, the social implications, as well as the impacts that this case has had. So, we are going to start with the public interest section. So, the old ways institutions were doing their admissions process was discriminatory towards Asian Americans. They had lower rates of acceptance despite being more qualified than students from other races. So this ruling is in the public's best interest as it is important that Asian Americans get the equality that they deserve when applying to institutions. This ruling is a step forward as all races will be able to be judged based off of their own hard work and qualifications rather than being judged based on their race. Next, we are going to discuss the social implications of this case. So, to start off, once again, race can no longer be taken into account for universities when they're doing their admissions process. So, this means that Asian Americans will now have an equal opportunity to get admitted into these universities compared to other races. However, because since race is not being taken into account anymore, the amount of diversity that these universities will have will decrease. Next, we are going to discuss the economic impact that this case has. So, universities that had used to consider race in their admissions plans will now have to spend more resources on developing new plans that aligns with the rulings. So, the cost that they will have to take on is the cost of staffing. They will have to take on the cost of development, the, the amount of time it'll take, and the money that they'll have to spend. But additionally, this ruling only takes into account the admissions process. This ruling does not apply to scholarships, so students can get scholarships based off of their race. Next, we are going to discuss the environmental impact that this case has. So, if universities must reconfigure the admissions process, it will take up necessary resources. These resources can include time, money, and staff. However, since these resources have to be taken from somewhere, they may be taken from practices that keep the university sustainable. Due to the loss of these resources, the universities could adopt new practices that involve creating more waste, which at the end of the day prevents the continuation of sustainable practices that creates a greener environment. Next, we are going to touch on the international impact. So, this case states that race cannot be taken into account during the admissions process. But because of this means that international students that come from different countries may have a more difficult time getting admitted into these universities, making it more difficult for them to come to the US. And finally, we are going to discuss moving forward. So, in conclusion, it was found by the Supreme Court that Harvard's admissions program violates the Equal Protection Clause of the 14th Amendment. The 14th Amendment basically states that you cannot discriminate against anybody for a variety of reasons. However, one of those were race. So in this case, Harvard was discriminatory towards Asian Americans, which resulted in lower acceptance rates, and that's why this case was ruled in the way that it was. And then finally, here are our references that we used for this presentation.